I thought I was done for today, but then this article just dropped a couple of hours ago, and so I had to share it right now. The executive order, I believe, was actually signed yesterday. I haven't read through this article yet. I just skimmed the first top, and I'm reading it live with you. So the title of this article from Newsweek is Trump Executive Order Raises Alarm Over Women's Financial Independence. As you can see, this article was literally published 5 hours ago. All right, let's dive in. An executive order signed by President Donald Trump is raising concerns over the protection of women's financial independence, as well as other potential civil rights violations. The EO, titled Restoring Equality of Opportunity and Meritocracy, is intended to encourage the meritocracy and a colorblind society, not race or sex-based favoritism. It calls for an evaluation of all pending proceedings under the Equal Credit Opportunity Act, which was first passed in 1974 and amended in 1976 to prevent lenders from discriminating against women based on marital status. Although the EO cannot change the law, that can only be done by an act of Congress. If independent federal agencies abide by the order, they will stall litigation protecting women from being discriminated against for credit, and they will roll back guidance and regulations which were in place to protect people's rights. Why it matters? Prior to the ECOA, women could be asked to have a male relative or spouse co-sign for their credit cards or loans. President Trump cannot single-handedly remove the ECOA, but his EO can make it harder for women to get federal help advocating against gender discrimination and can allow federally funded projects to discriminate based on gender. What to know? The EO's main target is the principle of disparate impact liability. The idea that racism, sexism, or some other form of discrimination can occur without explicit intent. The president believes that disparate impact liability is a key tool in a pernicious movement that endangers the U.S.'s foundational principle of creating opportunity, encouraging achievement, and sustaining the American dream. Ben Alinsky, Senior Vice President of Structural Reform and Governance at the Center for American Progress, the CAP, explained to Newsweek that disparate impact liability is a recognition that you could have certain hiring practices that, while not clearly discriminatory in intent, may have a disproportionate impact on a particular protected class. It could be where you advertise, for example, around employment listings. It could get at certain kinds of redlining practices. President Trump said, disparate impact liability not only undermines our national values, but also runs contrary to equal protection under the law and therefore violates our Constitution. They're trying to argue that it is somehow violating civil rights law and the Constitution to require employers or housing providers to consider the disparate impact on race or gender or age, right or disability. Alinsky told Newsweek, because that somehow might, in individual cases, cause a white young man to lose out because the criteria has been shifted. The ECOA is also intended to protect people of all races, color, age, and ability, creating concern that many groups could become subject to banking discrimination if federal agencies abide by this EO. Evaluation of the ECOA falls under Section 6 of the EO, which Alinsky explained to Newsweek means to the extent that there have been any kinds of consent judgments or injunctions or orders that have already been put into place, the government should revisit some of those agreements to see if maybe some can be rolled back. He explained that the order would likely result in the dismissal or quashing of any ongoing cases. The ECOA falls under the jurisdiction of the Consumer Federal Protection Bureau, the CFPB. The CFPB is supposed to be an independent agency, but the Trump administration has been working to couple independent agencies with the White House. This move has resulted in several court cases, however. Trump has appointed his own head of the CFPB, which he is allowed to do, and this head will likely follow through on this executive order. Not only does President Trump's order for restoring equality result in a reevaluation of judgments based around sex discrimination, it also calls for an evaluation of ongoing cases related to Titles 7 and 8 of the Civil Rights Act of 1964, and says, the Attorney General shall initiate appropriate action to repeal or amend the implementing regulations for Title 6 of the Civil Rights Act of 1964. Title VI prohibits federal funds from going to programs that discriminate against people based on their race, color, or national origin. Title VII prohibits employment discrimination, and Title VIII is also known as the Fair Housing Act, which is intended to prevent housing discrimination. Alinsky stressed to Newsweek that this EO does not mean people cannot file private suits. There are still protections in place for women and other minorities, for example, lawsuits against private companies. Alinsky stressed to Newsweek that this EO does not mean people cannot file private suits. There are still protections in place for women and other minorities, for example, lawsuits against private companies. However, without the federal government, there will be less data collection to aid in people understanding whether they were simply an individual denied a loan or if they were part of a discriminatory pattern, and there will be less support from agencies that are supposed to enforce, educate on, and regulate federal civil rights laws. What people are saying. Ben Alinsky, Senior Vice President of Structural Reform and Governance at the Center for American Progress, told Newsweek, "You will see fewer to perhaps no effort by the federal government to make sure that women have equal access to credit, that Black people have equal access to credit. I think that will likely be a consequence." But according to President Trump's executive order, that's quoted, "Because of disparate impact liability, employers cannot act in the best interests of the job applicant, the employer, and the American public. Disparate impact liability imperils the effectiveness of civil rights laws by mandating rather than prescribing discrimination." What happens next? Alinsky warned that the full legal consequence of this EO could come later, as these actions may work their way up to a Supreme Court case and to a bench that has shown it is willing to roll back Civil Rights Act protections in the name of equal opportunity, as demonstrated in Students for Fair Housing versus Harvard. Sorry, that's Students for Fair Admissions versus Harvard. Ladies, we've barely had the right to our own credit for 50 years, and now they are really trying to roll that back. Apparently, this is what making America great again is all about. Trying to ensure that women and people of color can be discriminated against at will and to limit our financial freedom and independence. It's The Handmaid's Tale. We're here. Please like, comment, share, all that stuff. I'm too pissed for words.